Hi, welcome to the Fall 2025 It's Your Money and It's Your Estate workshop series, brought to you by our 501c3 nonprofit organization, Financial and Estate Literacy. Our mission is to empower you to take control of your finances, your estate, and your charitable giving decisions. For the past 25 years, our founder, Peter Kote, as well as our entire team, have been providing these free, unbiased, and accessible 6-week workshops all over Orange County, California, as well as online, to help you make informed decisions that align with your unique needs and values. Let's start the program. This webinar is the 6th and last session of the It's Your Estate workshop series. The topic for today is Navigating Estate Administration. Our moderator is Peter Kote. Our guest speakers are Richard Huntington and Trevor Murphy. And this webinar is brought to you by Chapman University. Enjoy the workshop.
Today is estate administration, and we have Trevor Murphy and Richard Huntington, both professional fiduciaries, as I am as well. Let's talk a little bit about one of the most important things is that how do we check us out? If somebody says that they're a professional fiduciary, Richard, where should they go to make sure that we are one?
You're going to want to go to the Professional Fiduciary Bureau. It's a government agency through the
What
Department of Consumers. And let me get you there. So the website is, let me share this. Okay, so it's fiduciary .ca.gov. Once you get to the website, you'll be looking at this here. You want to go over to Quick Hits on the right side. And the first one is license verification. We'll click on that. And then we'll get to license verification tool. You want to click on that. You'll go to boards and bureaus. So first we have to identify which board we're talking about because, you got acupuncture and architects. They're all licensed by California. You scroll on down to professional fiduciary licenses right there. You're going to click on that. We'll put Pete's license number in there at 268 and verify you are a human. And then we hit search. All right, and then we've got Peter Kote, his license number. His expiration date is coming up in March of 2026, so it's an annual statement that each fiduciary is submitting to the Bureau. You want to go over here to more details on the right and scroll down from there. And we got the address, the office address for Peter. And then here on fiduciary information gives us a little more details. Let's see, total client assets of 40 million. When his last reported annual statement was, has he had any bankruptcies? No. Any removals? No. And any recorded resignations? No. So that's what you want to check out for each
Yeah.
fiduciary you're considering.
Yeah. You also want to just go back to the first screen, Rich.
Okay.
Where it says license status, that's important. It should say active. Some of them are inactive or they've retired or they've been removed, but usually active is the best one.
Yeah.
Yeah. Oh, yeah. Yeah. You don't want inactive. That's for sure.
There's approximately about 1,800 licensed fiduciaries in the state of California, and approximately between 70 and 80 here in Orange County. Quite a few are inactive. So if somebody says that they're a professional fiduciary, just like legal, just like financial, just like insurance, please look them up. Okay, these are there to protect the consumer. Let's go back. Richard, you've been a licensed fiduciary. What is your number?
310, 310.
And Trevor, what is your number?
822.
822. So we're all located on the Fiduciary Bureau. And I'm going to pull back up the outline that we're going to go through today. And first of all, Richard, why don't you start the discussion with how do you charge?
I charge a percentage of assets of trust assets that are under management. So if you add up the value of the home that's titled in the trust, any brokerage accounts that are titled in the trust, it's going to be 1% while the trustor is alive and incapacitated, and then it's a little bit under 2% after the surviving spouse has passed away for
And
the
what is
settlement
your
side.
hourly rate?
225.
And Trevor, how do you charge?
Well, it kind of depends on the fiduciary position that I'm serving in. So if I'm serving as the agent for power of attorney or advanced healthcare directive, and even some cases as trustee for incapacitated person. So if I come in on during incapacity, I tend to just charge hourly, unless I'm trustee for a trust that owns um, multiple real estate properties, closely held business assets, things like that. Then I will charge similar to what Richard charges at 1% up to the first 5%. I'm sorry, 5 million in assets, and then it blends down 75 basis points, the next 5 million, and then 50 basis points over that. Um, when the for the trust, which everyone knows because we're in the last week, but when the trust becomes irrevocable and becomes a separate entity, I also charge a management fee like Rich, and up to the same 1% for the first 5 million and so forth. From date of death until date of distribution is that sort of period of time when that fee schedule kicks in.
Yeah, let's. I'm going to talk a little bit about fiduciary, what it means in the estate planning area. Richard, in financial planning, we look for fiduciary financial advisors. Does that have the same meaning in the estate planning area when we talk about fiduciary positions?
Yeah, I think of it more of a noun. Like when we look at ourselves, we are a fiduciary. Our vocation is a fiduciary.
Well,
And then it's also considered an adjective. It's a fiduciary standard, meaning the best interest for the client. Um, so
but
it's
talk about the documents where you have the fiduciary positions.
Oh yeah, absolutely. So your four main documents, your will, your living trust, your advanced healthcare directive, and your durable power of attorney. You're going to be an agent is for durable power of attorney and also an agent for the advanced healthcare directive. That's that fiduciary position with your principal, and that's the elder. That's the principal. Your executor or administrator for the will, and you're named the successor trustee for the trust.
So
And those are
each one of these positions, you have fiduciary liability, and therefore they call us, since we are licensed professional fiduciaries. So it gets a little confusing because the word fiduciary is used now so much in the financial world as well. But when we're talking about the estate planning area, we're talking about serving in these positions. Uh, Trevor, can other individuals other than us professional licensed professionals serve as a fiduciary?
Of course, yeah. In fact, it's quite common for people to use family members to serve in these positions, and in fact, our presentation today is really um, geared towards that type of situation. And then, of course, you can also use corporate trust companies, corporations. Usually, they won't serve in the incapacity positions, but they will serve in the after death positions, let's say as an executor or a successor trustee.
So people use mostly family members. attorneys sometimes are
Yeah,
serve in that capacity. Sometimes CPAs do. Sometimes friends do. So anyone over the age of 18 literally can be serving in that capacity.
true. Yeah, yeah. There's no, it's really up to the grantor, the person creating the trust, or if it's, the couple, if they're a spouse, they're in charge, they're in control as to who's going to serve.
Yeah. One of the things is that Richard, you had made it a distinction, and so did you, Trevor, of serving during life and after death. What documents do you mainly use, or what happens if a single person who doesn't have anybody on title, why would they want to have a fiduciary named in these documents? I'm talking about a conservatorship.
Oh yeah, absolutely. So the first two documents, the durable power of attorney and the advanced health care directive, it's really imperative that you at least have those two documents because you're going to be you might be in a situation where you're incapacitated and you need someone to take care of you. And if you haven't pre-planned this idea and have an agent for you, then you're going to end up in the conservatorship program with the probate court. And it's just a terribly expensive program to be a part of in the conservatorship court.
Yeah, Trevor, talk about some of the things that are listed here on the page.
Go one more slide forward. Okay, good. um, this graph sort of explains the progression of your revocable living trust. So I just want to make a distinction here because we're going to be talking about the trustee, and your trustee needs to do this, and if you're serving as trustee, you need to do that. When you're alive and kicking and and you have your revocable living trust and you're managing your affairs and you're the beneficiary of your assets you own, you're all three. You check all boxes. You're the grantor, you created the trust, you're the beneficiary of that trust. All the assets in that trust are being managed for your benefit, and you're the trustee. You're acting. I mean, you're managing and have authority over those assets for your benefit. Now, we may, 2 out of 5 of us, maybe more, are going to live through a period of incapacity. And if you have a trust, and you do live through a period of incapacity, then what's nice about that is your trustee, who your successor trustee, can step in. I mean, that's why the box isn't checked there, because you're no longer the trustee, but your successor trustee can step in and manage your assets for your benefit. At least that should be the plan. You would hope that whoever you chose would be able to do that in an effective way.
Yeah.
And then, but most of the for our purposes today, we're going to be talking about the time when you're dead and we're administering the trust, which means that you're still the grantor. Congratulations, you live on with the new tax ID number, but you're no longer the beneficiary. That pivots to we look at your trust and the dispositive provisions and see what those say. And of course, you're no longer the trustee. However, I wanted to just pause before we get to the dead part to emphasize how important it is to make an estate plan and choose your successor trustee while you're alive and kicking, and you have clarity and you can make a good choice. Because if you do become incapacitated, your trustee very well may be determining where you live, whether you need to be placed somewhere and all that. They're going to be paying your bills. They're going to be taking you maybe, or at least arranging and managing your medical appointments, getting to those. They're going to control your investments. They're going to control you. They're going to prepare and file your tax returns. And then not only that, they should be communicating all this to the best they could to the rest of the family and friends and people around them. So even though today we're talking about a lot of time when you're dead, and it's so important. And I know, Pete, you've always emphasized this, in
The
your
estate,
lessons.
yeah, the estate planning documents are most important during your life, and they're not death documents because at death things get taken care of. Everybody wants things to be settled most of the time. But during your lifetime, boy, you better pick your trustee carefully. Yes, Don.
So on that line, there have been three questions that I want to put back to you guys at this point because I think they fit in. First of all, do all states have something like the Professional Fiduciary Bureau to look people up?
No.
No. California, well, as far as I know, there's only 3 states that have licensing. There's California, Nevada, and Arizona.
Yeah.
We are the only state that has an actual bureau that is subsumed there in the Department of Consumer Affairs for consumer recourse. So I think a lot of people get nervous about naming an individual because they're worried that we're this lone wolf out there with no regulatory.
That's the next question.
Yeah, okay. But that's not true. The Bureau is there to protect the consumers of fiduciary services. They're like our police, just like any bureau that holds a licensing, whether you're a CPA or a cosmetologist or whatever it is. So California really is on the vanguard of licensing. And in fact, when other fiduciaries from other states come to our statewide conferences and all that, they cannot believe how evolved our professional fiduciary licensing and field is compared to other states, which is a little more Wild West.
Okay, so now I name, as an example, Pete, who's older than me, so I can say this to him. So Pete either dies or retired. And do we have some kind of succession plan, or what do you do, Pete, if you've been hired, what do you do and next, what happens if I've hired you as a professional?
In the state of California, the law is that only trust companies, banks can be named in people's documents as a corporation. So you have to name individuals in your document. So professional fiduciary services, our group, legally you cannot name that entity in your estate plan. You need to name individuals in succession, and we always recommend that you name at least 3 individuals. So if you name myself or Richard or Trevor, each one of us works with our own individual groups, and we would recommend who would you name second, who would you name third, or you can name all 3 of us in succession. What you don't want to do is do co-trustee situations unless there's an exception that you think that might work. So
okay, the other part of that, however, Pete, is that's very good in terms of if you're professional fiduciaries. You should name successor trustees 2 or 3, whether it's individuals or whether it's you guys, because
absolutely,
no offense, all of us die at some point. And so that's just good management in terms of where they are.
Yeah.
So,
and a lot of people will name, for example, a corporate trustee because a corporate trustee doesn't die as maybe their 3rd or 4th choice in succession. So, but usually if they name 3 people in the family, first of all, I don't want to recommend that you name friends. You put them in a very awkward position having to deal with your family. So friends probably is just not a very good choice, especially for the financial part. But Trevor, you were about to say something.
Well, I just was going to say, to answer that question, is that we will look at your trust document to see the succession. So it's not like it doesn't automatically go to some other fiduciary in my office that works with me because I retired or died or stopped working. We would go back to your trust document and say, okay, what do the trustee succession clause say? Oh, okay, it says Richard's next in line. Okay, then Richard will be able to act. So and that's
we also recommend that you give the trustee the right to name a successor, which gives your document some flexibility. But it has to state in the document itself that you give the power to your successor trustee to name a successor.
Yeah.
Okay. What makes a good trustee? Richard, you want to take the first 4 or 5 of them, and then Trevor, you take the last 5? Go ahead, Richard.
Yeah, absolutely. So you definitely want to have the availability of time. So sometimes when you're thinking of a family member, they might be in their 60s at the time their parents pass away, and they're hustling, making money, trying to get their kids through college. So it might be a tough time availability issue. The desire to do it, obviously. Proximity is
Well,
kind of a big one
I
as
want to go
well.
back to
Oh,
desire.
oh
I
yeah.
have been named in documents without even person asking. You should please talk to the person to see if they're willing to. They may know, one of your kids may know more than you about working with their other siblings. So
Yeah.
desire is really an important issue.
Yeah.
Proximity, what does that mean?
Are they close to you? It's you want them to be there. They've got to be at the hospital if need be. They've got to be there to help you out with the house if you're going to be moving, and clearing out the house and selling it. So you want someone close to you, organized, especially on the financial side. You really want an organized person because you are paying bills, and you don't want any kind of commingling going on. You have to have a separate trust administration account, a separate accounting just for the dollars in and dollars out of that trust. Um, Ability to delegate is very important as well. Your trustee is not going to know how to do everything. They're not going to be doing your tax returns, but they have to have the ability to find the right CPA that can do a trust tax return. Same with a realtor. Everyone knows a realtor, and who doesn't know a realtor, but there's a realtors that don't understand fiduciary liability, and so you need the right type of realtor to make sure it's a done deal when that house gets sold. And then communication. I see that as the biggest problem is if your trustee is not communicating to everyone, that's where we get that pillow talk, and people start feeling uncomfortable with one person being the trustee and not communicating with the others about what's going on.
Yeah, so true. You've got to have somebody who can communicate. Trevor, let's transparency. What does that mean?
Well, that kind of follows up communication. So, um, I think we've been raised in a society where we're very private with our financial affairs and perhaps our job. We don't share too much to everybody. Even our kids, like how much money we have, what's in our IRA, this and that. But when you're a trustee, that you have a duty to account. You have a duty to communicate. You have to be impartial. So we're going to get to that later, but so it's being a transparent, meaning not only just in your um, what your plans are, but also financially too. I mean, if a beneficiary asks, "Hey, what's in the trust account right now?" and all this stuff, you pretty much have to be transparent and let them know. I mean, you may not have a full formal accounting there ready to give them, but you have to be really transparent as far as information. And nobody likes a BS artist in this position. It's too important, and so being transparent is there's certain people that are transparent and there's certain people that aren't, and you can kind of tell right away.
And
Um,
what does presence mean?
well, presence means I like to think of it as, okay, what presence does this trustee bring to the table? So and I'll put a literal kitchen table as a prop here. So you have the mom died, you have the four children around the kitchen table, because we got mom's funeral tomorrow and we got this, and one of them is trustee, okay, of and is going to be in charge. So what presence are they bringing to that situation? What can they identify and articulate a course of action that we're going to take? Or, I mean, if you and are you going to listen to everybody else? What presence
It's a
do they
leadership. Is you're talking about a leadership
kind
position?
of a leadership? Yeah, I mean, you don't have to be like a Napoleon Bonaparte kind of character, but you just need to kind of be in control a little bit or feel like have others feel. So for example, the opposites of this would be like a bully. Someone, eldest son flies in from New York, says, "I'm not listening to anybody. Mom chose me. I'm in charge. So talk to the hand. I'm not listening to you. Well, I'm
That
not
doesn't
saying
work very well.
it doesn't work well. You've already lost people's trust,
And
right?
then the wallflower.
The wallflower is almost worse. The wallflower happens probably more frequently where you name your nicest, sweetest uh, child, but when they get into that kitchen table, they're more like, "Oh, okay, well, whatever you guys want, it's fine. I'll just do whatever." It's just because people aren't. There's a reason you were chosen by the person, and I hope it wasn't just because you were nice and friendly. I hope
And not just because you were the oldest. And
yeah, not just because you're the oldest. So you kind of want someone in the middle that'll be assertive, but will also listen and take people's points of view and not make them feel excluded. I guess is
yeah.
that's really
What does bondable mean?
well, bondable. This is kind of comes more into play in the estate administration, but it can also come into the trust. So when you make a trust, most of you will what's the word? Exclude the bond or not
Yeah, waive the bond.
waive the bond. Yeah, you would waive the bonding requirement. And what a bond is, it's a surety bond that ensures that if the trustee were to steal or abscond with the trust funds, then if they're bonded, then the bond company will make it whole, and then they'll go after the individual who stole it.
Yeah.
Now, if you're worried about someone stealing your money, why name them, right? So,
Yeah.
but then if it does get into court, let's say with an estate administration and you're named executor um, or administrator, you come in, the court, unless you've waived the bond on your will, they will also make sure you're bondable. And that means you got a good credit record, you have no bankruptcies, you don't have a criminal record. There's a lot of things that
Yeah.
come into that.
Competence,
Competence for
usually people who are named have never done this before. So what do you mean by being competent?
Yeah, I mean, you don't have to be an expert in trust administration. You just have to be competent and willing to learn, what it takes to be an effective trustee,
Yeah.
and
This,
and and all the different things, delegating, getting professional advice, just so it'll help with your just being competent
this,
as
the standard is what would an ordinary business person do in a likewise situation?
yeah.
That's
Mhm.
what competence means.
Yeah.
A
And
record keeping and efficiency. I think they kind of go together.
they go together. So, well, record keeping again, like Richard had said, there you're going to have to keep good records because whether you're first of all, you're going to have to present an accounting at the end. You're going to have to also keep separate and identified any income they earned before they died because you're going to have to report that on their 1040 versus the 1041 in the same year after they died. If you're going to pay yourself, or if the trustee's going to pay themselves, they're going to have to keep good records of their time, and so they can apply that to an invoice, let's say, and all that. So it's just some people, and this is where I think a lot of people get in problems because they're not good record keepers. Or at least they haven't done it, and so
They
and
treat
not,
the money like their own, and this
yeah,
is not their. See,
yeah,
when somebody becomes suffers from an incapacity or death, the money part of it goes into a kind of a limbo period. It doesn't belong to the beneficiaries yet, and yet it doesn't belong to the grantor because they're deceased.
yeah,
And so this limbo period, everybody wants to know where happens to the money. And
exactly.
so every dime that gets spent and every dime that comes in needs to be recorded.
Yeah.
Um,
You got to
talk
pay. You
about
got to
it.
pay taxes too, and what I mean by efficiency is, and maybe this deals more with professional trustees, but for example, we all have multiple trust administrations going on at once. So if you're going to have, let's say you have a house, a family home, and you have all the personal property you got to deal with, you have everything in there. Rather than, on Monday, I go up and meet the real estate agent. On Tuesday, I go up and meet the estate sale agent. On Thursday, I meet the mover hauler. You can get everybody there at once and be efficient instead of, this whole thing. But
Yeah. Yeah. Well, that goes to, the length of time that it takes to resolve a trust administration, and usually it's somewhere between 9 to 12 months, depending on the type of assets. But personal liability, Richard, I mean, you mean the trustee is going to be held responsible?
Yeah, it's a unique situation. So when you think of financial advisors, they only have a limited power of attorney just to get their fees out of your account. So they don't have custody of your monies. Whereas a trustee, they have full custody of your monies. They step into your shoes and they have control of your money. So with that becomes a lot of liability and a lot of responsibility at the same time. So you really got to be thinking through your decisions. Just like Trevor and Pete were saying, that it comes down to what would a prudent person do in this situation, and you got to ask yourself what's the best decision to make,
Yeah.
because you do carry a lot of liability.
Yeah, and that goes back to your ability to delegate. You know,
Yeah.
you've got to be, you gotta have a good CPA, you have to have a good attorney. So to guide you through this, even us professionals, we need those individuals to settle an estate. Yes, Don.
You just made a very interesting point of you need a good attorney, you need a good CPA, you need a whatever. How do you find these people? How do I mean, the three of you sitting here are wonderful people and would make wonderful fiduciaries, I'm sure. Are there any others? Is there a list somewhere? Do you have where do I find a good fiduciary
You
other
can
than you?
find Trevor happens to be the president of the local professional fiduciary association. What is as the president of the Orange County chapter, Trevor, what do you suggest?
Well, well, the first step was what we did at the beginning is if you find someone, check their license. But and by the way, Rich is also on the leadership. He's the treasurer of the chapter. So, but the having said that, the Professional Fiduciary Association of California, the short to PFAC, has very good resources for consumers to navigate and learn more about our profession without it being this government website. I mean,
Where can I find out about that? What is there an address, an email that you're
Yes,
going to put in the chat?
yes.
I'll put it in the chat. But yes,
Thank
Okay.
you. And
yeah,
send it to
yeah,
everyone.
yeah.
Yeah.
Now they do have a list of professional fiduciaries that you can scroll through and stuff now. But keep in mind, not every California licensed professional fiduciary is a member of PFAC, so it's not absolute. It doesn't have every fiduciary in the state
It's a
in there.
starting point.
It's a starting point though, and it does it's a good starting point in for a consumer to learn more about the profession and to. But I do, like Pete said, if you are considering, talk to two or three of us. You know, we're all a little different. We're individuals.
We have different personalities.
Different personalities,
Very,
Even the
very
three of you,
important.
yes.
Yeah.
yeah,
Yeah.
yeah.
There's
So
also another way I usually, if I had to, somebody calls me and says, could you recommend fiduciary in another state or another county where I'm not familiar with anyone? I go to the National Academy of Elder Law Attorneys, and they're a national organization. And Trevor, you can put that into the chat box, please. And I usually, these are attorneys who focus in on elder law and usually are the ones that are familiar with professional fiduciaries in their community. So most of us as fiduciaries, professional fiduciaries, need an attorney. And so why not get a referral from an elder law attorney in that particular area that to use. So, and I've had very good luck with that. So those are three good ways. Most estate planning attorneys have professional fiduciaries that they have worked with in the past and should give you 2 to 3 names as well. Richard, let's talk a little bit about, I don't want to spend an enormous amount of time on this, but unlike other professions or fiduciary duties are spelled out in the probate code, in the law. So go through some of these and what they mean. What does it mean to say duty to administer the trust according to its terms?
So yeah, when you have a trust, it's a contract, and all the words and language and duties are going to be spelled out in that trust. So if you had a power, different various powers as trustee, and it did not allow you to sell real property, which would be, kind of ridiculous, but if that wasn't in there, you can't do it. So
You know,
you can't sell.
the common one that I see is, mom told me that, or mom and dad gave us $15,000 every Christmas. And moms, when are you going to send us the check? And unless it's stated in the trust that you can make a gift, you can't do it.
Yeah. Yeah,
Yeah.
absolutely. I see that one also with the tangible personal property that some of the kids wanted this fancy dresser, and I say, okay, well that's going to be $700 for me to ship it to you. Let me get your credit card. And they say, wait a minute, no, I don't want to pay for this. And so it has to be in the trust that the trust is going to pay for shipping and handling of these things as
Yeah.
well.
The trust is the Bible.
Yeah, yeah, absolutely.
And which
Let's see, follow written directions from the trust store. I see that with there's a sheet when you get your trust package, there's going to be a general assignment of tangible personal property. And that really helps. You could say diamond earrings go to Judy. I want the gold chain going to Johnny. So yeah, it gives you written direction from the trustor on how to deal with things. Duty of loyalty, that's really a big one. You got to remember there's a dynamic shift in loyalty. So when the trustor is alive, and incapacitated, and you are the successor trustee, they are the beneficiary. You're taking care of them. So your loyalty is to them. Your loyalty is not to the remainder beneficiary, the children. But when that trustor passes away, then there's that switch. Now your loyalty is to the remainder beneficiary, and that's important to understand.
And
Um, yeah,
and the next one, it goes right hand in hand in that, and because now most individuals name their kids as a trustee, and they have to treat everybody impartially.
yeah, that could be a tough one, especially when the matriarch passes away. You've got one of the kids as trustee, and all this baggage just seems to come up to the surface. You stole my truck when I was 13 years old, and I've never forgiven you for that, or whatever. So you really got to have treat everyone fairly, impartial, listen to everyone, communicate with everyone.
I had a
And
situation where the oldest son was the trustee, and he wanted mom's car, and it was a brand new Mercedes, and she had very low mileage on it, and he wanted that car for himself. So under under the duty of loyalty and the duty of impartiality, what he needed to do if he wanted that car would be to offer that car to his beneficiaries first because he's the trustee, and he has to be totally impartial, so to all of the beneficiaries, and offer that same price that he was willing to pay for it. And if they give them, the children, permission at a particular price, then it's okay for him to purchase the car. And I would make sure that all of that is in writing. These are these are specific duties that of a fiduciary. What does it mean, self-dealing?
you're not, you're in the office of trust administration. All the assets are part of the trust. So there's no there's no handshake deals. You can't sell a property to your friend. You can't have it for yourself. Everything's got to be out on the open market as you think. So you think of
Yeah.
like eBay, to sell a piece of jewelry, or think of a house, you got to get it on the MLS. It has to go out to the whole country to see that this thing is for sale.
Have you said, Trevor, had any issues with taking over a trusteeship where someone was self-dealing and had to be removed?
Yeah, I mean, there's certain like it well, yeah, I mean, there's a lot of times where we come in as professionals where the family member trustee has been self-dealing. Like I had one where the the there were co-trustees, there was blended family, two, one representing each side. And the one of the co-trustees was not putting the family home on the market, was trying to work with all the other family members to try and get him to sell it to him. Like he was using his position as trustee to better himself rather than everybody else.
Yeah.
And he didn't know any different. It wasn't like he was doing it in a way that was, but also simple things like often you're a real estate agent and you've been named trustee. Okay. And you're taking fees for your service. Are you also going to charge a commission that you as trustee determine, to sell the house? Because now you're wearing two hats. You're the trustee and the real estate agent. And so you can determine what your commission is. You can determine, what your kickback is. You can write that contract to deal yourself. There's that. I've seen it with contractors, who are trustees where their construction company, they'll hire their own construction company to fix up the kitchen so we can list and sell the property. Like those are all using the office of trustee, your fiduciary position to better yourself rather than everybody else.
Richard, what does it mean to keep the trustee property separate, identified, to preserve and control?
Yeah, sometimes you might have, community property. You might have a blended marriage, and you've got community property, and then you might have separate property from your first marriage, or maybe an inheritance from your own relatives, and so it's got to be identified that way. And when you step into the role of trustee, you got to be able to list all those assets and identify if they are community or if they're separate property.
What,
And
what I what I see a lot is daughter or son is taking care of a parent. The parent dies, and now they're living in the house,
yeah.
and they're not nobody's collecting rent. Do you have a duty to charge rent now that the parent is gone and the caregiver daughter is still living in the property?
Yeah, absolutely. Absolutely. It's always a fun discussion to have with that person and say, hey, you know what, the party's over now. You need to either pay rent or you have to move out.
So,
Um,
so if you have that situation and you want the daughter to be there rent free for a year to find another place, please make sure that's stated in the trust document, because the duty is to make all assets productive.
yeah.
Um, there's also the duty to preserve trust property. Let's say I'm going to give you a situation, Trevor. I own about $2 million worth of cryptocurrency. Uh, I die. What would you do with my cryptocurrency?
Wow, that's a tough one. You gave me a tough one, Pete. Because crypto is a weird thing in this world, but
It's a very simple answer.
yeah,
Well,
you gotta
the duty is to preserve.
preserve. Yeah, so probably would liquidate that
Yes, as soon
uh,
as possible.
as soon as possible, especially if it's a distribution. Now, obviously, you look at the trust. If it said give my crypto to so and so, they would, But if
Yeah,
it doesn't have any specific instructions, then I would, yeah, liquidate that, preserve the capital, get it ready for distribution, so we're
yeah.
not.
And then if the beneficiaries want to reinvest in the crypto, more power to them.
Yeah,
Uh,
it's funny you say that one, Pete. I got one just now that the rumor is that the guy passed away unexpectedly. He's got crypto on a broken phone, and I need to try and find it. And it's just, kind of hearsay from the friends that he has this. So I've got 5 broken phones. I'm getting over to a tech guy to see if we could get into this and try and find this crypto. So it's really
Well,
a rabbit hole.
one of the things I love about our jobs is the interesting situations that we get into, and
Always
the different
different.
family situations and the different assets. It's just
Yeah.
it never gets boring. Let's say Richard, I'm in charge of a house, and the situation before, daughter's been in now in the house for 2 months, doesn't plan on paying any rent. She tells me that mom promised her that she could stay in the house for another year. Uh, what would, what would you have to do?
We're gonna have to get her out of there, and if she's really putting her heels in and doesn't want to leave, then we're gonna have to take legal action. We'll have to hire an unlawful detainer attorney and get an unlawful detainer started. It will give them a 3-day pay or quit, and then we just keep going down that avenue until we get to a point where the sheriff arrives and we have to kick her out of there.
Yeah.
And
And
yeah.
so if you have a son or a daughter as your trustee, their duty is to do this. Let's say mom lends son $50,000 to start a business. Son says, "Hey, mom told me that if she died, uh, the debt is forgiven, but there is nothing in writing." What's your duty there?
Actually a tough one. You want it to be in your documents saying, "Hey, I lent Johnny 50,000 with a promissory note," and that makes it enforceable to collect. You just if it's not written out, then it's all kind of a hearsay. We don't know what really happened because we weren't involved then.
Trevor, what does it mean to exercise supervision?
Well, every time, so the best way to put it is, if you're a trustee, you're like a CEO. Okay, so you don't have to do everything yourself. However, you have to make sure everything gets done. And so a lot of that is prudently delegating, whatever it may be, whether that's selling a house, whether that's mover hauler services, or even gardening or anything, financial services, trust, CPA work. You are prudently delegating that to a professional that knows what they do. But because you're the trustee, you have to also independently monitor them to make sure that it gets done. Because if they mess up, it's your fault if you don't independently monitor them. So and that is a lot of the work is prudently delegating and independently monitoring the people doing the work for the trust. Now
Eh,
there are things that cannot be delegated. You cannot just say, "Hey, Rich, I want you to take over as trustee for this trust, but I want to remain named as trustee." It doesn't work that way. You have to, be there for certain things.
Yeah. The last one on the list here on 16062 is the duty to report information to account. I would say 80% of all lawsuits are about accountings. Talk a little bit, Richard, how important accountings are.
Yeah, they're really
And what
important.
are they?
So it's a duty that you have to report to all the beneficiaries that it shows every dollar in and dollar out since date of death of the grantor, and you have to justify it. So it's you can't willy-nilly pay something off where you don't have a source document. And then there's two ways to do them. You could report it where it's just all showing all the expenses in and out, giving them a copy of the bank statements. And then we also have court style accounting, which is a very specified way to do an accounting where you have receipts and distributions and you have different schedules that's going to show the same. Either way you do it, you still have to get it out to everyone at least annually is a requirement. And then if there's a statute of limitations of 3 years for the beneficiaries to object to the accounting, unless it's specified in the trust, there could be a 180-day statute of limitations that could be specified in the trust, which we recommend that you have it in your trust, and that limits it down to 6 months. But yeah, it's got to be as soon as you present the accounting, then you're going to have the beneficiaries asking you questions. You need to explain why you spent $200 to pay San Diego Gas and Electric, and you just tell them, there's no way to fight that bill. We have to pay it.
Yeah.
So it's very important.
Accountings are absolutely huge, and beneficiaries can waive an accounting.
Mhm.
But we recommend highly that you do an accounting, and you want that statute to start tolling, and it's 3 years unless it states otherwise in your trust agreement. And so attorneys draft these documents. It's similar to a driver. We have a car designer, which is the attorney. The fiduciary or your successor trustee drives that car. And these kind of are the rules of the road that we need to follow. I'm going to go to the next slide. The estate and trust administration are very, very similar, except in the trust administration, we're not going to court. So, which is hopefully the ideal situation. Uh, Trevor, talk a little bit about this slide.
Well, it's just it again, there was a question earlier in the chat, what's the difference between a trust administration and a estate administration? It just means that an estate administration is done whether it's probating a will or probating somebody's intestate estate. It's linked to the individual and it is court supervised. That's the main thing to understand. The job, the work, a lot of that's the same. We're still marshaling assets. We're liquidating things. We're dealing with personal property. The difference is the environment. So court supervised. Think it takes longer because you have all these hearings and there's all these, and then you have it's more expensive, and so if you have a trust, we have a trust administration, and it's administered privately outside the court, so it's less expensive, doesn't take as long. However, it does put a lot of pressure on the trustee to know all the codes that govern us because we don't have the black robe there to help us out if things go awry. So it doesn't mean it's necessarily better. It just means it's different.
Yeah, it's, most trust administrations, no matter how bad, they don't end up in court. And only,
Sometimes they do.
huh?
Sometimes
Sometimes
they
they
do. I
do.
think that's the next slide.
Yeah, and they don't want, and you don't want that. So you got to be,
Yeah.
diligent about, uh, your family. You got to be realistic. And if you think there might be litigation, then you got to let your attorney know so they can prepare the trust document because there's language that an attorney can put in to protect the trustee. Would a successor trustee ever go to court?
Yeah.
Yeah.
Yeah. And that's what I mean is that, so first of all, these next slides are kind of going to get more into the actual administrative tasks and duties as we go through. But people think all the time that because it's a trust administration and therefore it's not in probate court, that it never gets to a probate court. It is still that, the domicile of this administration is the Orange County Probate Court if it's in Orange County. So if a beneficiary has an issue and needs to file a petition because they're complaining that the trustees breached their duty, they would file that petition with the Orange County Probate Court. So there's times where you can find that, there's the trustee has to send out what we call the 120-day notice within the first 60 days of the person's death. The trustee sends out a notice that says, this trust is now irrevocable. The office of trustee, this is how you contact the office of trustee. The domiciled in Orange County, that's the court. Oh, and by the way, you have 120 days to file a petition if you feel there's been any undue influence, blah, blah, blah. And then once that 120 days lapses, you cannot go back and file anything. A trustee may also use the court for certain things like notice of proposed action if there's a decision they need to make that they know will be divisive amongst the beneficiaries and maybe kind of get in front of any litigation that may happen. So there's other, just because it's a trust administration doesn't mean it never goes to court, but that's our goal, is to keep it out.
Yeah. So one of the first things, if you have a family member, one of the first things they should do is contact an estate planning attorney to advise them as to the procedures to take, because they're going to be held personally responsible if for any kind of breaches, and you don't want to do that. And so if you hire one of us as professional fiduciaries, we know the area, we can limit the amount of legal time that we have to spend with an attorney. So usually our fees are are similar to a private individual who has to hire an attorney for for much more instructions than we have to. The cost of dying is approximately between 3 to 5% as to the second death. What are we talking about, Richard, here? Appointment and powers document setup.
Right. So we got, let's see, the
What, so
estate plan.
somebody dies or somebody becomes
Yeah,
incapacitated? What do we do?
locating everything. Yeah.
So you want the original estate planning documents. Sometimes the clients are going to have a set of that. It's like a 3-ring binder. It's going to have all your estate documents. You want to find that. And that's going to have your originals. And usually your drafting attorney might be holding a set of the originals as well.
Where should
Um,
they keep these documents?
I would
In their
somewhere where you
safety
can find
deposit
them.
box? Should they
Yeah.
have them in the safety deposit
No,
box?
no, do not put them in your safe deposit box. You can put a copy of them in your safe deposit box if you want, but we need to get to those right away to be effective.
Yeah, put them
So
on a
you want,
cabinet shelf. I've
yeah,
never heard anybody trying to steal those documents.
correct. And you're going to have your funeral arrangements if you've pre-arranged. That's going to be part of it in those documents as well.
Uh,
Um, and
Acceptance and resignation forms. So we want to make sure that there's a chain of title, so to speak, or as to the trusteeship. So,
Absolutely. So let's say a spouse passes away, and the surviving spouse is now the trustee, and then that surviving spouse becomes incapacitated or just doesn't want to be trustee anymore. So they're going to have an official resignation, and then it's going to drop down to your next successor trustee, and they're going to need to have an official acceptance. When that first spouse passes away, we want to get at least, I'd say, 10 death certificates.
how long
Just
does it take to get a death certificate?
last one I got it was about 2 weeks.
Yeah,
Um,
not that difficult. Does everybody need a death certificate as far as institutions are
yeah,
concerned?
every institution wants to see an original, and you'll get them back, but you have to submit an original to them.
Um, I'm gonna,
Every real property too.
yeah.
Yeah, yeah.
What is a an employer identification number?
That's going to be what we call an EIN number. You're going to get that from the IRS. It's a very simple process, but what we're doing is we're putting this into its own vehicle now. It's an
In other words,
irrevocable
you don't
trust.
use the person's social security number.
Correct. Yeah. Yeah. No more Social Security. It becomes its own business in a sense.
Yeah. So how many tax returns usually are there involved in the first year, Trevor?
If you count federal and state, there's at least four. Two for your 1040, 540, and then one, and then two for your 1041, 541. If there's also a probate alongside, you're going to have another, because that'll have a separate tax ID. But if you have a trust, you probably won't. If you're high net worth, or maybe even a surviving spouse who wants to port their spouse's
So one of the first things you want to do as well is hire a fiduciary or somebody, a CPA who's familiar with fiduciary tax returns.
Yeah.
You
Yeah,
know,
definitely. I mean, listen, tax returns are not fun for anybody, but for somebody who's serving as a trustee in the year that the person dies, it's actually quite a lot to get together all the stuff you need for that. So you got to make sure you get the right professionals that can
and
help.
remember, beneficiary designations pass outside of all these documents, and whoever receives those benefits, are we boring you there, Trevor? Or
No,
anyway, whoever receives those benefits they have to pay the income tax on it. So there's sometimes what we get is they name the living trust as a beneficiary on IRAs or 401ks. Make sure that you talk to a CPA before you withdraw monies out of those accounts. Let's see, estate letter certification, we're not going to go there. Talk a little bit about tax related to death, Richard. Take the first three or four, and then Trevor can take the next three or four.
Yeah, absolutely. So, one of the remaining duties that you have when you're the agent for the Advanced Healthcare Directive, most of all your duties dies with your principal, but one of the remaining duties is arranging the funeral and burial wishes of that person, and also ordering the death certificates is another duty there. So you want to get that done. Obviously, you're going to be notifying anyone that you know that's related, any family members, any close friends that so and so has passed away.
Yeah, but how
Um,
do you find who to notify?
that could be a tough one as well. It's so in my practice, we have contact information from our future clients. I think with a family member, if your family member is the trustee, then they're obviously going to know their brothers and sisters. They might not know the close friends as well.
Yeah,
But
so what you may want to do is that put a list together of whom you want to be notified of your death or incapacity. And
yeah,
that way, whoever is going to be your trustee can notify them. Uh, Range from mortuary, cemetery, or burial.
yeah.
Uh, is that ever a problem in a family?
Yeah, it can be. I mean, everyone, each one of the kids could have a different idea and don't want to do cremation and are, want it to be buried. And so having it
Different
prearranged is,
religions have different
yeah,
types of rituals. You want to spell it out as to what you want, or you may want to spell it out because you're going to be deceased. You may want to ask your children as to what they want.
yeah, yeah.
You
And,
know?
and having it prearranged is just wonderful. And it kind of tails into that next point. It takes away that emotional aspect because you've already arranged with yourself and the family of how you want it to be done.
Yeah.
Um,
If for loved ones, is there an emotional impact?
Yeah. Oh, yeah, for sure. Especially the spouse. When your spouse passes away, you guys might have been together 50, 60 years. You count on that first year of just being set back and not really able to handle any major decisions.
Yeah, and it's also usually the family is there for immediate support in the first, kind of 30 days.
Yeah.
But, everybody leaves, everybody goes on with their own lives. And you want to make sure that there's some support there for the first year to year and a half.
hmm
Of
hmm
course, the pets, we want to make sure they're taken care of.
Yeah. Yeah, absolutely. You could have dogs or cats and you got to deal with those right away.
Yeah, we'd suggest if you do have a pet that you say whoever is going to be caring for those pets to give them some monies, 10, 15, $20,000, and it gives them some incentive to take care of your pet for you for the rest of their life. How about Trevor? Do we still do obituaries?
hmm
Yeah, you can make your own. You can create your own. Um, Sometimes I even get clients that explicitly say, do not do an obituary or do not do a formal funeral or anything like that. They're really adamant. So either way, you gotta respect your client's thing. Um, so the in regards to uh, so yeah, meeting with attorney, of course, Pete mentioned that. I think it's really important, especially for family members, to get an attorney to help with the trust administration.
Well,
Uh,
one of the first things, Trevor, that we do is try to figure out how do you hold title to the assets?
oh yeah, yeah, that's true. We got to find how we hold title.
Because
Uh,
if it's in the trust, well, we put our trustee hat on.
yeah.
What if it's in the person's own name?
Well, if it's in our okay, then we got to look at. how many assets, what's the value of all the assets in their own name that do not have a beneficiary designation attached to payable on death beneficiary designation attached. Basically look for what is the value of their total probate estate. If it's over $208,000, then we may have to open a formal probate. If
Yeah.
it's under that amount, then we can do what's called a small estate affidavit process. And we got to wait 40 days after death, but it's a pretty simple process to marshal that asset into the trust.
Yeah.
Uh,
So
yeah.
title is really important. How
Yeah.
about do we ever have to locate heirs?
Yeah, and this is really important because on your trust, one of the reasons why they have um, a family information page is so when the trustee sees that they can identify not only who the beneficiaries are who are in the trust, but also who the family members are, because there is a notice law that we have to notice not only the beneficiaries of the trust, but also any immediate heirs that are, let's say, not a beneficiary of the trust. And those can be complicated. So an attorney will help you kind of parse out who that should go to.
Yeah. These are some of the documents that we need to locate and review. Um, let's say, Richard, that you can't find the or
Pete, before you do that, Trevor, you made a comment a moment ago of what's the threshold for probate dollar amount? 200 and
Um,
something.
208,000.
208,000. And
Thank
then
you.
there's also a new law about a primary residence you can have up to worth of 750,000. And that can avoid a formal probate.
Gross or net value?
Gross.
So in
It's
other words, if I have a mortgage, if I have a $750,000 residence that has a $500,000 mortgage, the 750 or whatever is the one that counts, not the net value.
Correct.
True. It's always
Yeah.
gross in
Correct.
probate court. Yeah.
Okay. Thank you.
Yeah.
Let's say, Richard, I have a house and there's no insurance on it. You take over as trustee, and a month later, it burns down. Who's responsible?
You're a trustee. Yeah, you're named on that house. So you're gonna the house is titled in the trust. So it could be the Smith Family Trust, and Susie and Johnny Smith were the original trustees. But now that those trustors are passed away, you are the trustee, and you're carrying the responsibility and liability of that house. So yeah, that's a really a tough scenario.
Yeah, one of the things that you got to remember is that uh, if most individuals name a family member, but the question is, should you pay the family member to be the trustee, or should you not? The family member that you named has just similar liability as a professional fiduciary. We have a little higher standard, but the liability is still there. Yes, Don.
We have 10 minutes and 10 pages.
Okay, we'll
Either
get.
hurry up or run way, way long.
Yeah.
Thank you.
Well, thank you, Don. These are all the documents that you need. We'd like to review them prior to your death to make sure that we understand how you have things titled. And we also want to, in the engagements of professionals, we talked a little bit about that, attorneys, CPAs, banking or financial advisors. We do not manage money for the long term. If we have to have a trust that maybe say will last 10 years since the child is 5 years old and we need to manage the trust assets until they're of age 18, we hire fee-only fiduciary advisors. We have to work with insurance agents, professional appraisers, etc. We talked a little bit about tax notices. We talked about the real property has different issues that we have to give notice of. If you're a VA, we have to make sure they're aware. And definitely, we also have to inform creditors as to whether or not whether we have a trust or we have to go through probate. Creditors have to be notified. Sometimes we can, what's called, there's an indecision. We have a diamond ring. We have three daughters. All of them say, "Hey, mom promised me the diamond ring." What we can do is instead of going to court, we can propose a solution. We sell the diamond ring and split whatever the money's between the three of them. It's called a notice of proposed action, and a lot of times that saves individuals from having to go to court. Um, Trevor, talk a little bit about marshaling inventory and appraisals and kind of summarize this page.
Yeah, so I'll summarize. One of the major things you do as a trustee or an executor is marshaling assets. Now, assets come in many different things. We have personal property assets that say, the act of marshaling and securing those would be changing the locks on the house, reviewing the personal property memorandum and the trust to see if there's any specific um, personal property items that would go to any specific people. Uh, just being aware of that. Other assets will be financial assets like the bank accounts, brokerage accounts titled in the trust. You're going to have to take the new EIN. You're going to have to take the death certificate to the institutions and marshal the assets, and that basically means move them from the old tax ID of the Social Security to new accounts in the new EIN under the new tax number.
And
Uh,
that's the probate code of preserving and identifying the
oh yeah,
trust assets.
yeah. You'd be fulfilling your duty to that code for sure doing this, and then of course real property assets is too. A lot of us die with those.
But
So
you have a couple of them in bold there. I want you to talk about that.
well again. As keeping records of everything, meticulous records, your activity, tasks to be concluded. I have like a checklist of everything that has to get done in a trust administration. Um, and then documenting any important decisions. So, for example, an example would be, okay, how did you come to the the price that you're listing the family house on? Because it's up, how did you get to that number? Well, we got a date of death appraisal. I've conferred and got input from my real estate agent. Every time we come to a price, I always ask the real estate agent to email me to say and tell me why we are selling at that price. And in a paragraph, in an email, so I have it documented. Therefore, if I get any questions later as to how and why, I have it all ready to go. And it's just a good um, habit and a good.
Yeah, well, again, the liability is that are you making your decisions along that of a prudent
Yeah,
business person in a like kind situation? And
true.
so you want to be able to document your decision process so that everybody understands, even though your decision may turn out to be a wrong or a negative outcome, as long as you were rational in your decision process, you should not be held liable.
Totally.
Um, the consolidation of trust or estate principle, uh, it, basically, again, it's segregate, separate your assets, make sure that whether it's real property or a personal, that is carry it out prudently. That the sale is prudent, that you get rid of the personal property prudently, and that you carry out the instructions of the grantor as written in the trust. A lot of times people don't spend enough time reading their trust and to understand it fully. But
Next slide.
We understand that trust backwards and forwards. Prepare final distribution to beneficiaries. Um, Richard, what do you do before you distribute to the beneficiaries? You
Well,
provide
yeah,
them an accounting?
yeah, everyone's going to get an accounting from every dollar in and dollar out since the settlers passed away. And they're going to review that accounting. There might be some questions back to your trustee, asking why did you spend money on this or spend money on that. You're going to get them to understand what what the accounting is saying, and then they're going to you want them to sign off on it. You want them
Yeah.
to say, okay, everything looks good.
And if
And
they don't sign off of it, then there's always the alternative of going to court and having a judge sign off on that.
yeah, absolutely.
So
So
how long?
therefore, how long would this take, Pete?
Yeah, yeah, yes. It could take up to
Thank
two
you.
years, but most times it's up. It usually is less than 12 months. Most times somewhere between 9 and 10. But
If it's
remember the
outside of
100,
probate.
huh?
If it's outside of probate.
Yes, if it's outside of probate. Remember the 120 days? Uh, After a death, you don't go to an attorney immediately. So usually there's a month or so before the trustee steps in and goes to the attorney. So, it takes just the time where not a lot of stuff happens except for kind of organizing the estate. Um, what can you do to make the estate planning more easier? Have all your documents updated. Make sure you understand how you have title to all your assets. Make sure you inform your professionals that who you want them to use. Prearrange funeral plans. Keep organized records if you can. We talked about California license process, so we're going to let that go. You can read this on your own,
Yeah, these three are
and
just they were at the end for
yeah, that's
information.
the end. So let's open up, stop sharing, and let's open it up for Q&A.
I think a big issue that's come out of this thing, and it's one we've always faced, is the executor the same as a trustee? The only beneficiaries are the one that get the stuff at the other end, but executors.
Terminology. It's
Yes.
terminology.
So is the executor of a trust the same as the trustee?
No,
Is the
no.
trust
Executor, when you talk about executor, you're talking about a named person in a will. If somebody administrates your will who is not named in the will, we call them a personal administrator. Just, you
quite
know,
another term?
I can explain. So executor is you nominate an executor in your will. What that means is when you die, it doesn't mean that person is automatically the executor.
no, I have to
It
be a,
means they're the nominated executor. So if that will is probated and it gets to that hearing where the judge needs to appoint someone to be the personal representative for that estate, they will then most likely honor the wishes of the testator of that will and appoint the executor at that point executor. But it has to go through court. So,
yeah.
but it's a term we always use. So we use it, but executor of a trust, but it's really the true. And you're in the class, you got to know this. It really means it's a nominated position in a will. It is not related to a trust.
Successor trustee, agent for people's health care. We serve in that capacity as well. Usually, family members name one individual to be the healthcare directive. We would recommend highly that whomever you named as a successor trustee should also be named as your executor and also your durable power of attorney. It just because that particular individual manages money. If you're going to name different people in your estate planning documents, make sure that they get along really well. Because if one has a emotional issue with one of the other kids, they'll take it out in the estate planning process. Anyway, is there any questions in the chat or Q&A? Do we answer everything? Geez,
I answered a lot of them, and others are, I've just asked you a couple of them along the way, so we've done a good job with that. So
yeah. Who did you're naming your two daughters in your trust documents, aren't you, Don?
after my wife.
After your wife. See, and that's very common. Richard, what have you done with your documents?
I haven't done them yet, to tell you the truth.
Procrastination.
Yes. Yes.
Procrastination is just the number one reason, for us not doing it. So,
Trevor, how about you?
Yeah, I've got an estate plan, and I have my I believe my brother-in-law is going to be our immediate successor if something happens to both of us.
yeah.
Good. Yeah.
And
James, I like James.
Yeah, James. Yeah, he's getting his license, fiduciary license up in Northern California, but
Does someone now that raises an interesting question. So if I'm a family member, do I have to have a license to do this?
No.
So
you only need a license
friend,
if you do this for 2 or more cases that are not family.
right? Yeah, and that's true of a friend also. But if the friend was doing 5 estates, then that's a problem. But you don't. But the issue I think that comes up in here, and why we beat the heck out of these rules, is that these rules apply to anyone who's doing this, whether they're licensed or not. The people who are licensed know it better.
The liability is just huge because you're responsible for the entire accumulated savings of the individual that they have over their lifetime. And now you're responsible for making that distribution. So
a couple of years ago, we were doing a session live, and Pete had asked the question, have any of you been administrators or executors of estates? Hands go up. How long has it taken? 2 years. Hands come up. The last guy with his hand up, he'd been the executor for 29 years. And you want to talk about litigation? And it hadn't settled yet in 29 years. That's one of the reasons you might want to consider a professional fiduciary.
Yeah, we have a county of 3 million individuals. And so just like a bell curve, that the vast majority is going to be okay, but there's going to be a small percentage that there's going to be problems. The thing of it is that small percentage is just a huge number here in Orange County.
When my father passed and there was second to die, my sisters and I sat down and said, what do you want to do? This is what we want to do. Okay. We knew the creditors, we knew all the other issues that were faced, and did it very briskly. But
and
there was a trust, and we were able to do it. So
and all you have to do is be over 18, and you can be named. And
we could prove that we were over 18. So
also, I don't mean to. You also should not choose anyone that is not that does not have a social security number. Meaning, sometimes people that have international families may name a brother that lives in Canada, for example. The problem is when we're in that process of marshaling assets and all that, the banks are going to want a social security number to deal with this sort of thing. Same with now, if they have international beneficiaries, they can receive it okay. It's more the person acting as trustee.
Yeah, there's 2 rules here. There's one, the probate code, and then there's the institutional policy of that corporation. Yeah. And so Wells Fargo, Bank of America, US Bank, Schwab, JP Morgan, Merrill Lynch, they all have their own policies. And so regardless of what the probate code says,
they don't go lockstep together.
They never do. And so you got to comply in order to marshal that asset. You got to comply with that institutional's policies. And sometimes that's difficult.
I urge that all the attendees, watch the video in slow motion after we finish this, because there's an awful lot of things that we're considering or we're talking about, and a lot of issues that are going on. So, but at this point, at what time it is, I'm going to say, thank you, Richard. Thank you, Trevor. Thank you, Pete. Thank you for the audience for being here. I'm going to turn off the recording, but I want to say first, this has been financial and estate literacy. This has been It's Your Estate, and we've been talking about trust administration. And I thank you all. And I'm going to turn off a recording.